This is Duke University.
Anyway, I am really excited about this panel, and I'll tell you why. There's been this perception of national security law that, oh, national security law, yeah, that's for people going in the military, going into the government, or maybe they want to work with an NGO. Actually, national security, as I tell my students oftentimes, it's a $700 billion business in this country. In a globalized world, it's even bigger. There isn't a client that will look at the front page of a newspaper and not see something that implicates national security, and particularly in relation to business. And this is the piece that we haven't always emphasized enough. What are the national security implications on business activities in a globalized world, especially as we look forward, because there's lots of things that have happened in the last 10 years that actually have effects on business, but we don't, it's not always in our consciousness. And one of our rising stars here on the Duke Law faculty, Professor Julie Maupin, has kindly agreed to be the moderator for this panel. If you look at her biography, it's really eye-watering. Not only does she have all kinds of expertise in international business and international business financial regulation, she's also was the founding board member of the Truman National Security Project, and she consults for a number of different groups, and she's completing, not only does she have her law degree from Yale, she's completing her PhD studies in international law at the Graduate Institute of International Development Studies in Geneva, Switzerland. In this respect, she reminds me a little bit of Joseph Blocher. There's a lot to hate about you, Jewel.
Great,
because she's an immensely talented person, and I really appreciate her helping us with the conference here. Julie?
Thank you. Well, I'm starting to think that Professor Dunlap is the king of the backhanded compliment this conference. Thank you very much for inviting me to participate. It's really an honor and a pleasure to be here, and I'm learning a lot. I just wanted to say it's a particular privilege to be in a context where I'm surrounded by so many members of the military and the intelligence community and the law enforcement community, because it's not often that people who do economic law get to be in that setting. And I should just tell you before I start, as a personal anecdote, I had originally, as a teenager, hoped to be among you. I was hoping very much to go to the Air Force Academy. I got a congressional nomination and passed all of the initial tests and everything. But there was one small hurdle, which is that I literally cannot do a pull-up to save my life. And despite having lifted weights for 2 years to try and pass that physical exam, that was the only thing that kept me from going to the Air Force Academy.
Oh,
so,
the Air Force made a good decision. Because after all, she might have had to pull up her way more.
I might have, you never know. So that is why I stand before you today as an academic and not a test pilot, which was what my dream was. But, I'm very happy with how things have turned out as well. But it's a privilege to be here. As Professor Dunlap said, there are a lot of really important connections between national security and business. And a lot of them kind of fly under the radar. And people don't think about them a lot. Certainly you don't hear them talked about as much as you do things like humanitarian law and the laws of war. And there aren't many Latin phrases that you can throw around in economic law. So it's not as sexy in some ways. But there are a lot of things, there have always been some things that we knew were intersections between business and national security law. And many of them are sort of old areas with new twists since 9/11. One can think of economic sanctions, which have been in use for a long time, foreign ownership of sensitive U.S. assets, which is something that Ted Kassinger is going to discuss a little bit, visa policies, immigration control, controlling foreign researchers coming to U.S. universities and foreign workers, that sort of thing. And then there are some other new and emerging areas. One is defense outsourcing, which Phil Carter is going to talk a little bit about, national security letters under the U.S. Patriot Act. And then there are some that are a little bit more far afield that people don't talk about a lot. I want to mention two that have come to my attention in the last couple of years that I think are really interesting and will have a lot of implications. The first is international commercial arbitration as a means of money laundering for terrorist organizations. How many people are aware that this is happening? So not that many, right? I mean, it doesn't get a lot of attention. But when I first heard about this, I thought, well, that's just kind of crazy paranoia, right? I mean, you have commercial arbitration happening around the world all the time. But if you really think about it, it actually makes a lot of sense. It's pretty easy to set up a business in many countries. You can do it with $100 in a 3-page form. And to generate a fictitious dispute between two companies in 2 different jurisdictions that go to international arbitration, then you get a binding arbitration award for a couple $100 million. Very, very commonplace in the commercial arbitration world. And then because we have this lovely thing called the New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards, you can enforce that award in 143 countries around the world, which is much, much easier to do than to enforce a foreign court judgment, by the way. So you can actually enforce these things. You can attach assets. You can move money from a country that would normally be on a blacklist or would be viewed with suspicion in any of those 143 countries. So this is something that has long been used by organized crime, the mafia, and what have you for drugs and guns and human trafficking, and now has attracted the attention of terrorist organizations as well. So that's one example. The second example, which there was a really interesting post about financial warfare in U.S. News and World Report in January of 2012. It was an opinion post by a macroeconomic analyst named James Rickards, who participated in 2009 in a war game simulation that was sponsored by a number of different defense and intelligence agencies in D.C. And they all came together and they sort of simulated a fictitious financial attack on the world's financial system. And they had different people play for different countries, and they engaged in all sorts of strategery, as they say. And then he wrote this article in 2012, and he was talking about the Obama administration's decision not too long ago to strengthen sanctions against Iran by threatening to exclude any international bank that does business with Iran from the global dollar payment system. And of course, the global dollar payment system being what it is, the international banks immediately complied. But what happened as a result, in addition to Iran's currency crashing 40% and immediate hyperinflation being injected in the economy and all sorts of chaos happening in Iran, which was the point, we saw these really interesting workarounds. So India and China are big buyers of oil and various other things from Iran, and so they worked around it by working out gold standard swaps instead. And the upshot is that use of strategic warfare like this for a country like the United States, which is the world's reserve currency, can have huge implications, because the more we use tactics like that, the more it gives incentives to those who do business not to use the US dollar, which actually eventually will cause a crash of the US dollar if we do it too much. So there are a lot of really interesting interplays between business, finance, business, and national security. And one of the most interesting questions, I think, for me, is what can we expect from the private sector in terms of national security vigilance? How should our expectations differ along the spectrum from those who know that they're engaging in national security sensitive industries like defense contractors on the one end, to, on the other hand, people like international commercial arbitration law firms who may have no idea that what they're doing might have national security implications. So with that, I'm going to turn it over to our distinguished panel of panelists here. We're going to start with Ted Kassinger, who is going to talk to us a little bit about the implications of foreign direct investment and talk a little bit about China.
Thank you very much, Julie. And permit me also first to thank General Dunlap for inviting me. He and I first met last fall, I think it was, at a conference, and I had not heard of the Lens conference before, but he came up to me after a panel and described what it was and said he wanted to do something really different and to introduce this new dimension into the discussion of national security issues. And I thought it was a great idea, and I have to tell you, every panel I've sat through the last day or so has just reaffirmed that. It's the seamlessness of the subjects are really remarkable, both on a personal level and with people I've seen, but also subject matter. On a personal note, just for example, the prior panel, Dick Jackson's daughter is a star associate at O'Melveny and Myers, former Duke grad, but so glad to see Dick here. I was amazed to hear Admiral Houck's background. One of my brothers-in-law was the skipper of the Cairn immediately after Admiral Houck departed. So a lot of personal connections. Deborah Pearlstein, in her just terrific remarks yesterday, did a great job of noting the expansion of the notion of national security into many different dimensions and the importance of having that discussion and how one defines it. It is a fairly boundless discussion. I'm going to take it even further and, as Charlie suggested, do something different in this context by, I think, for the first time talking in this conference about something that is not law. So I'm going to move into a not exactly lawless area, but an area that is really policy. There's a legal framework that governs it, but we're not going to talk about rules much. We're going to talk about an area that's incredibly important within a legal framework. All of you are hoping for CLE credit. You can put down your pencils now. What I want to talk about is foreign direct investment in the United States as a national security issue. The reason this is not a particular area of law is that for two reasons. One is that for more than 2 centuries, as a matter of economic policy, the United States deliberately has not legislated or regulated in this area. The second is in the time period of just the last 20 years when foreign direct investment took on more of a national security concern and some legislation was passed, that we'll talk about, the principal focus of that. It's an area entirely within the discretion of the executive branch. There is no judicial review of the kinds of cases I'm going to talk about. There is no case law out there. Reviews are conducted in confidence. They're case-by-case approach. You just sort of have to know what's going on to get a feel for the process. But we are in an area really of policy. So I'm going to do 4 quick things on a double time march and then hopefully have a lot of time in Q&A. I want to define what we're going to talk about, so we have put some bounds around it. What is foreign direct investment? I'm going to give you a quick overview of the legal framework. Third, we're going to drill down in the most important area of discussion, I think, relevant to you, which is review by something called the Committee on Foreign Investment of the United States of foreign investments for national security reasons. Talk a little bit about how CFIUS works, another good acronym to add to your collection. And finally, particularly in a context of where are we going from now, I want to talk about what I think will be the most important item on the discussion for you and everyone else over the next decade, and that's foreign direct investment from China. Represents a very interesting set of emerging issues that we really have not seen before. So first, what are we talking about? Foreign direct investment. If your grandmother, still in Armenia, decides to provide for her grandchildren here and her future by buying U.S. Treasury bonds, that's a kind of investment in the United States. She can do that. She can buy bonds. She can buy stock in Microsoft over the New York Stock Exchange, or in case of Microsoft, NASDAQ. She can buy stock in Verizon if she's really looking to secure her future. There we go. And those investments are important, and they're really important. Raise capital in the United States, help the United States balance its international accounts. Nobody worries about that from a national security standpoint. Then there's another kind of foreign investment in the U.S. It's something in between. It's kind of the next step. A lot of wealth accumulated in many countries around the world, Middle East, Canada, elsewhere, put into what are called sovereign wealth funds. Could be, say, the Ontario Teachers Pension Fund, or it could be China Investment Corporation. It could be Mubadala Development Corporation or the Abu Dhabi Investment Authority, where they collect national wealth and invest it abroad for investment purposes. same thing. It could buy a chunk of Citibank, say, for 5%, or give money to an investment manager in the United States, which reinvests that. Again, generally, we welcome that money. It's great for the U.S. Doesn't typically raise national security issues. It's passive. The equity holders aren't looking to manage U.S. companies or be involved in management. They just want to see the monthly statements and how much they're getting on their return. What we're going to talk today is about the third category, often referred to by the acronym of FDI, Foreign Direct Investment, in the United States. Various ways of defining it, but the way the U.S. government defines it, and it's generally used in international standards and by statisticians, is an investment of 10% or more where the investor holds the voting interest of at least that amount. And it's kind of a direct equity interest. So in that case, you're thinking about people who may be more active stockholders and who are perhaps making more strategic investments. They want to know more than just how much they're making at the end of the day. They're interested in the business, and it could be for a variety of reasons. So that's fundamentally what we're going to be talking about. Now, for 200 years, the United States did not have a statute that said the United States has authority to block those foreign investments on national security grounds. And it is true today that anyone can go in, set up a North Carolina corporation, put a little money into it, set up shop on outside the campus here, start selling cupcakes or cars or whatever else you want. That foreign investor doesn't have to go to anybody in the United States to ask for permission to do that. There's nobody that could give that permission. It's just, we have an open economy, and that is a very good thing, and that has been the policy of the United States. As articulated since at least Ronald Reagan, by every president, but every party, the United States welcomes foreign investment. Like the capital it brings, the jobs it creates, technology often that comes with that. And that has been the case forever. In the 20th century, in a few selected and very few areas, Congress acted to cap foreign investment at certain levels and for national security reasons, really. And in some cases, make it very difficult for foreign investors to operate businesses. So, for example, in the communications business, you can't get a wireless license from the FCC if you're more than 25% owned by foreigners. Verizon is in no danger of being taken over by the Russian telecommunications company. The same thing is true in the airline business. Can't have more than 25% ownership of a U.S. airline. American Airlines in bankruptcy today would probably love to talk to British Air about a merger, but that's not going to happen. You can have all kinds of code-sharing relationships, operating relationships, all those kinds of things, but you can't have foreign ownership. Nuclear industry, another obvious one. Other than in uranium mining, basically as you go through the downstream segments of the nuclear industry, no foreign ownership of control. So there are a few of those. Case of airlines, the maritime industry you may be familiar with, similar restrictions. Communications go back to the 1920s and 30s and have been there. But there was no general regulatory statute. In the 1970s, after the Arab oil embargo, a huge amount of currency exchange built up in the Middle East. A lot of that money started finding its way back to the United States, often in the form of buying farmland, agricultural land. And this caused a political uproar. People were very concerned about Middle East investors owning farmland in the United States. There was a statute passed that requires, even today, reporting about foreign investments in agricultural land, but no prohibition. But President Ford, in response to that political crisis, not a national security crisis really, created something called the Committee on Foreign Investment in the United States, CFIUS. CFIUS is chaired by the Treasury Department, has been from the beginning. Treasury champion of international economic policy issues in the U.S., the leader staunch promoter of open borders in terms of investment, given the chair. Other agencies, defense, commerce, state, a few others, sat on the committee from the beginning, but it had no power other than to review foreign investments, make reports. 1980s, the next decade comes along. That decade brought a wave of investment from Japan. Japan and its economic ascendancy, yen very strong against the dollar, made U.S. assets cheap. Huge amounts of money coming in from Japan. Rockefeller Center, Pebble Beach Golf Course, a lot of bad investments in real estate by Japanese investors. But there was also a wave of takeovers of technology companies, the most well-known of which was Fujitsu buying Fairchild Semiconductor, an iconic Silicon Valley, one of the original leaders in the semiconductor industry. Political uproar again. This time, Congress enacted a statute. We've heard a lot about titles of the U.S. Code. Interestingly enough, the statute that was enacted wasn't in Title 31, where a lot of the Treasury Department authorities are, or Title 15, where Commerce Department authorities are, Title 22, the U.S. State Department. It's Title 50. But you have to look hard to find it. It's the appendix to Title 50. It's Section 721 of the Defense Production Act of 1950. It was then called the Exxon-Florio Amendment to the Defense Production Act after Senator Exxon and Congressman Florio. And for the first time, 1789, 1988, that's when the statute was enacted, the President was authorized to block foreign acquisitions of U.S. companies on, or U.S. businesses, let me say, on national security grounds. There had never been that authority before, and the statute was very short. It just made this authorization. The President, then President Reagan, delegated a lot of the work to CFIUS, which existed. And so there then began, just within the last 20 years, really, this strange process where the government can review foreign investments and block them on national security grounds. National security not defined. It is, as Justice Stewart, Potter Stewart once said, you know it when you see it, and this is how CFIUS operates. 1990s, things calmed down. There was the occasional uproar. 1991, LTV Corporation went into bankruptcy. Thomson, CFS of France, made a run at buying its missile division. Big uproar in Congress. That died down. Statute was amended, but basically it was quiet. Beginning in 2000, however, there began to be a series of increasingly difficult cases. When I showed up at the Commerce Department in 2001, CFIUS had just finished looking at and clearing the acquisition of a company, an internet provider, services provider company by NTT, a Japanese company. We had on our plate the acquisition of a semiconductor equipment manufacturing company by a Dutch company, ASML. It was pretty controversial because that U.S. company was the last manufacturer of that particular kind of equipment in the U.S., so there was sort of industrial-based issues. 2003, Hutchison Whampoa from Hong Kong attempted to acquire the assets of Global Crossing out of bankruptcy. Basically blocked. We blocked that with CFIUS. 2004, Lenovo, Chinese company, accomplished what remains the single biggest Chinese investment in the United States. It bought the IBM's PC business. You may remember this. Pretty controversial, cleared by CFIUS. Then 2005, Chinese company CNOOC, Chinese National Offshore Oil Company, took a run at Unocal after Chevron had entered into an agreement to buy Unocal. This, again, blew up politically, and that's something we can talk a lot about, why that happened. CFIUS actually never looked at that deal because it was never a deal to look at. It was a bid that was ultimately not accepted. But tremendous controversy in Congress. CNOOC backed away. 2006, Lucent sold itself to Alcatel, French company. Very controversial, took a long time. CFIUS finally cleared that under a set of very stringent agreements. About the same time, and most famously perhaps in your memory, a company called Dubai Ports World bought a number of port facilities assets in the U.S. that were owned by a British company. So this was one foreign company buying assets that were already foreign owned. CFIUS cleared that deal. And then suddenly, then Senator Clinton and Senator Schumer from New York appeared front page New York Times, Statue of Liberty in the background, saying this was the worst thing that anyone could ever imagine. Those wonderful people who sent us the 9/11 terrorists have just bought the Port of New York. So this was, again, caused an uproar, which ultimately led to a major amendment of the statute, the Defense Production Act in 2007, that for the first time gave a statutory basis to CFIUS itself and the authorities that it's had. So that's how we got to where we are. What I wanted to do in the next last little time I have is to just give you a context for thinking about what we're about to see. And it's mostly about China, although not exclusively, as the Alcatel deal showed and as several others have showed. How do I flip through the...
Well, I've been going through a couple of them. You're on China's, we went through the CFIUS stuff.
Okay.
And then...
okay, so you can skip that one.
Okay.
Okay. I just wanted to, giving you a little context about China. Oh, actually, let me go back up. Okay, so this just gives you a quick snapshot of foreign exchange reserves that have built up in China over the last decade. 2000 is the year that China joined the World Trade Organization, established normal trade relations with the U.S. and other countries around the world, and it's a very export-driven economy. A lot of things we could talk about there, but the main point is a lot of money building up in China. It's got to go somewhere, right? Just a little note on CFIUS filings, just to give you a picture on what's happened over the years. Not many cases, right? Not many cases. There roughly, last year were, by some outside estimates, 900 or so acquisitions of U.S. companies by foreign companies. There were about 100 CFIUS reviews, so not many reviews. So outbound foreign investment from China has, from 2000, same point, exploded. That money looking to go somewhere, invested, and the Chinese created something they called the go out policy. So affirmatively encouraging Chinese companies to look out, invest abroad. Just some quick pictures. I want to caution you that the data in this area are really hard to come by. Official statistics are calculated on different ways. They don't, it's hard to compare apples to oranges. And this happens to be a slide that the Heritage Foundation drawn from data that they've put together, but it has limitations. But just to give you a rough sense, the main point, energy, power, Chinese looking out. Where does it go? Spread around the world. A couple places. So $2 billion in the U.S. maybe last year. There was, by U.S. official statistics, $270 or so billion worth of new foreign investment in the U.S. So China, not a big player. We don't have much time, but I just want to leave you with these thoughts. There's this huge buildup of currency reserves and other money in China. It's tightly controlled in terms of the money coming out. General Motors wants to build a plant in Australia or China. It doesn't have to go to the U.S. government and ask. It just puts the money together and goes and builds it. In China, if you want to take, well, first, if you get money in, you sell a widget, somebody in the U.S., they send you dollars. You have to convert that to RMB. The government gives you RMB, they take the dollars. If you want to send that RMB out into an investment abroad, you have to get the government's permission to do that. You have a lot of approvals, different agencies involved. So outbound investment, very tightly controlled. It has been estimated that over the next eight years through 2020, there'll be somewhere between $1 trillion and $3 trillion of Chinese outbound investment going around the world. Senator Dirksen very famously said about the federal budget, billion here, a billion there. Pretty soon you're talking real money. 1 trillion is a lot. 3 trillion is a whole lot. This is something I do, just quick arithmetic. But suppose you say $2 trillion total, and only 5% of that goes to the United States. It's a small amount. You know, you could do a straight line accounting exercise. That's about $12.5 billion a year, each year beginning 2013, or this year actually. That would be about 10 times the amount of Chinese investment that came last year. So, you know, a lot of that could be really good stuff. Last couple of years, Chinese companies have bought 2 failing U.S. auto parts makers. Got them up and running again, creating jobs, preserving jobs. All that's good. But this is in a context of cybersecurity, which several of our prior panels have addressed. It's in a context of commercial espionage, which is endemic. There are numerous arrests out there that our friends here at the Justice Department certainly know about. Some in the news just within the last month or so. You know, a couple of people indicted in California for stealing DuPont trade secrets. How do you feel about Chinese companies owning infrastructure companies, utilities, ports? There are a number of questions here that we saw to some extent in the 1970s with Middle East investors raising public concerns, Japanese investors, 1980s. But this is the next few years. You know, we're talking about where we go from here. There's going to be such a large amount of money coming from China, which would do great things, but it's different. China is not aligned with the United States as an ally of many other countries, Japan. And there is a record at the moment of bad behavior that gives it a concern. So I'll close there just saying this is the job of CFIUS as they look at particular investments involving China and the U.S., and it involves a lot of complicated policy issues.
Great. Can we go right in? Great. Thanks, Ted. Great overview of CFIUS. Thanks for that. And thanks for the plug of Verizon. I expect I'll be getting a bill 6 minutes for plugging Verizon next month. A couple prefatory comments. First, I, like others, want to add my thanks to Charlie Dunlap for the invitation. It's a pleasure to be here. And also, I really want to commend him. I think he talked to me about this a number of months ago, his vision of bringing in the private sector into this national security discussion. I think it was really far-sighted because I think this is a real emerging trend for reasons I hope to tease out here a little bit. So, Charlie, thank you and well done on the conference. Secondly, just on a logistic point, I know Charlie told you to put away your cell phones, put them on silent. While I'm talking, if you're a Verizon customer, text away to your heart's content. If you're not a Verizon customer, you probably can't get connectivity, so I don't really care. And third, and slightly more seriously, I do want to acknowledge that there are a number of issues of private sector and Verizon in terms of national security that I'm not going to address, and those are for 2 primary reasons. First, it probably should go without saying, but I'll state explicitly that I'm not going to talk about anything that Verizon does do, is alleged to do, is suspected to do in terms of national security activities with governments, with any government in the world that is not public. So there may be a lot of interesting topics to be discussed, but this obviously is neither the time nor the place to do so. The second is, as Admiral Hook alluded to, there are areas where the line, and when we get into cyber, blurs between law enforcement and national security. There are a lot of interesting debates going on right now about the proper legal framework for, say, access to stored email or access to location information through mobile devices that we all now carry with us. We could talk all day about that alone. I'm not going to touch on those. If someone wants to talk about it in the Q&A, I'm happy to do so. But I want to acknowledge there's a whole set of issues that we won't touch on. Here's what I do want to talk about. First, I want to just give a brief introduction to Verizon to provide the context of why this is an issue for us. Secondly, I want to make a few observations about the intersection between the private sector and national security with a particular reference to cybersecurity. And then third, I just want to make a few brief observations about how the world looks sitting as an in-house counsel and providing legal advice in terms of national security issues, because I think it's a slightly different lens through which we need to see it than those of you who are looking at it from the government perspective, maybe the academic perspective. And for those of you, students or otherwise, who might want to practice in it, I think it's useful to know. So first, let me just do a brief introduction to Verizon. Now, you probably, I presume, have all heard of Verizon. If you think of us, you probably think of us as your wireless carrier. At least I hope you do. If you live in the Northeast, you may think about us. Can you get the slides? If you live in the Northeast, you may think about us from a consumer wireline perspective. We're building fiber to the home across our footprint in the Northeast. We provide television service, broadband, internet. What you may not know us as well as, and these two areas, by the way, are extremely important areas of our business, obviously. So great, that's good for now.
Can I just pass this down to you?
Okay, sure. Technology in real time. Okay. So our wireless business, our consumer wireline business are incredibly important areas of our business. Less interesting from a national security perspective. Now, I say that in a relative term. We process hundreds of subpoenas and other legal process every day, literally tens of thousands every year at Verizon. And some small percentage of those are national security letters and other things having to do with national security. But those are fairly, for purposes of this discussion, are fairly routine and workaday. What you may not know about Verizon, because it's not a consumer business, so it doesn't show up on our advertising. Sorry, down? Yeah. Okay. Is that we are one of the largest providers. You see this technology in action here. We're a high-tech industry. We are one of the largest providers of global communication services to government and industry. Almost every single one of the Fortune 1000 largest companies on the planet are customers of ours. We're a major supplier of services to the US government and to many other governments around the world. We own and operate one of the largest internet backbones in the world and own capacity on dozens and dozens of cables around the world. So what's connected to all of this? Well, just about everything, right? What travels over this is your cell phone calls, your fixed line calls, your emails, your web browsing traffic, your text, movies, architectural blueprints, intellectual property, just about anything you can imagine. You all know the type of interconnected world we live in, but this is where it flows. It's flowing in photons, electrons through fiber optic fibers that run all around the world, owned primarily by private sector companies like Verizon. This is an area in terms of data that is growing at tremendous rates. There are lots of stats that you can hear about this. I just want to give you two to try and give you a sense of scale. First, just on the mobile network. We predict that within the next 10 years, before 2020, there will be 20 billion mobile devices connected to our network. 20 billion. Now you say there aren't 20 billion people on the planet, nor will there be in the next 10 years. You're absolutely right. These aren't people, this is machine-to-machine technologies. Your thermostats, your refrigerators, your automobiles, almost everything that we have you will see embedded increasingly with internet protocol, and it will be connected to the network. It will all be flowing over these networks, a tremendous amount of data. Second, just to give you a sense of scale, a technical analyst group called IDC estimated that cumulatively by 1999, the total amount of data recorded by humans, all the books, all the movies, all the music, totaled 12 exabytes. Now, I won't try and give you an illustration of how much an exabyte is. For purposes of this, here's an illustration. 12 of them equal all the recorded stuff set up to 1999, right? So this is a lot. So just think 12 units of a lot, all cumulative up until 1999. Same analyst, 2011, estimated that in 2011, there was 1.8 zettabytes, which is 1,800 exabytes of data in 2011 alone. In other words, last year alone, there was 150 times more data recorded than in all of human history up until 1999. This is growing very, very quickly. The amount of data sloshing through these global fiber optic networks is absolutely extraordinary. This is why this is of interest in the realm of national security. Okay? So let's talk a little bit more about the intersection between the private sector and national security. Historically, if you look at it, how did the private sector come in touch with national security? A couple of different areas. One, you could be a supplier. Classic example is, of course, the defense industrial base, but there are many other things. For a long time, there's been concern about continuity of government in terms of the electric grid, communications, and other things. And Phil's going to talk a lot about the supply. The private sector is a supplier to government. A second is as an evidence holder, right? Certainly in my industry in communications, for as long as there's been communications, governments have been interested in the content of those communications, whether it's the internet networks, phone networks, telegraph networks, back to early mail systems. That's always been so, and it will always be so. A third area is as a victim. Now, this is an area in the United States that's been less common, to some degree out in shipping, but simply by virtue of the fact that there's been less armed conflict within the continental U.S. There's been less issue of private sector as victim in a national security context, although the notable example, of course, is September 11th, where there were years and years of very complex legal issues coming out of the attacks of September 11th. Ted very ably covered CFIUS, but CFIUS is something, it tends to be more episodic, but if you were involved in any sort of merger and acquisition activity on a cross-border basis, CFIUS is a possibility. And it pops up in areas that you might not even expect. I will simply say we at Verizon have multiple national security agreements that have been negotiated with the U.S. government over the last 10 years or so in the context of different things we're doing, some of which actually weren't even mergers and acquisitions. They're simply license acquisitions. It's part of our day-to-day lives. And then finally, depending on whether you consider this part of the national security firmament or not, export controls, sanctioned country regulations, that's simply part of the furniture at a multinational company in terms of your fundamental compliance obligations. So these historically are the areas that you would look at and say this is where private sector really deals with national security. So what do we see as trends today where this is changing? When we talk about supplier evidence holder, certainly the volumes are growing, certainly for a company like Verizon, simply because of the ubiquity of interconnected communications. It's a bigger factor that government needs, and as I pointed out before, the volumes of potential data are growing astronomically, but that's a difference of degree, not of kind. Fundamentally, that is the same. CFIUS, OFAC controls, export control, you can talk about ebbs and flows and enforcement in different administrations, but the world fundamentally looks the same there. What is new is a couple of areas, and I want to touch on two primarily. First, in the last 10 years, largely because some of these issues have played out so publicly and so controversially in the United States, national security, for better or worse, has become part of a discussion for customers of multinational companies, particularly US-based companies. Let me give you a specific example. We at Verizon are one of the largest providers of cloud computing data centers. I won't go into what cloud computing is if you don't know, but watch for it. This is a major trend. We own cloud data centers in Europe, Latin America, Asia, as well as here in North America. There is active discussion going on, and it is actively being pushed in marketing materials by companies all around the world that companies outside the US should not buy cloud computing services from US headquartered companies because under the US Patriot Act, we will have to turn that information over to the U.S. government. Now, I won't get into detail on this, but let me just say as a side, this is a complete misreading of what the Patriot Act does, or the fact that the Patriot Act is the source of any extraterritorial new powers by the U.S. government. But frankly, that's irrelevant because perception matters here. This has gone to a degree that I actually have someone who monitors the global press and every day provides me with a set of press clips of where the USA Patriot Act is mentioned around the world. So let me just read you two samples from yesterday's press clips. This is what was sent to me yesterday. A European company launched a new technology solution. In their press release, they said, quote, "The solution does not use any software from American manufacturers. This prevents access to cloud data by US authorities under the USA Patriot Act." Same day, out of a paper in Asia, an analyst talking about cloud computing said, quote, "Don't forget that since the USA Patriot Act came out, all US companies have to turn over any data they acquire, even if it is stored offshore." This is being discussed on a day-to-day basis by sales guys in commercial negotiations. You say that's good, bad, or indifferent, but it's part of the world that we have to live with. I'm now in a world where I have to provide talking points to my sales guys around the world of how they respond to a question about whether we will turn over information to the US government under the Patriot Act. Of course, as you can imagine, I'm a bit handicapped there for two reasons. One, this isn't something that we're going to talk about a lot in terms of what we do in terms of turning over data to the US government. And again, I will emphasize that this represents a complete misrepresentation of what the Patriot Act says, and this is really referring to national security letters. The second is, you can't prove a negative. Right? You can say all day long this is what the law says, but if they say, will you guarantee me this doesn't happen, you can never say no. So this is an area where this wasn't going on 15 years ago. Today, this conversation, something that traditionally was treated as much more confidential, much more secret, is happening in the commercial space. Commercial analysts are recommending that their customers ask suppliers these specific questions. What are your policies? What are your practices in turning things over? And of course, this is an area that you neither confirm nor deny when it comes to national security. The second area is, I mentioned private sector as a victim. The issue of private sector as a victim, and I want to add a new factor, which is as a vector of attacks. In today's world, everything is interconnected, and the world's global internet networks are all interconnected. And 80 to 90% of that is owned by the private sector. 50 years ago, if someone were to launch an attack on the US power grid, somebody or something had to penetrate the defensive perimeter of the United States. And guarding that defensive perimeter was a government function. Today, that attack potentially could take place without any physical penetration of U.S. national sovereign physical territory, leaving aside the esoteric question of whether electrons and photons are a physical presence. A person, a missile does not have to cross into the borders. What's more, the vector of that attack is going likely to be privately held, privately owned network assets. This aspect, increasingly, of the private sector as a potential victim of cyber attacks, as well as the vector of cyber attacks, raises a number of interesting questions. And Admiral began to touch on this earlier, and so I don't want to retread some of the ground that he very ably raised, but some of the additional questions, in addition to that, how does one distinguish between law enforcement and national security in this space? Where are those lines? Does the government have a role in protecting private sector critical infrastructure? If so, how do we define that critical infrastructure? Do you define that role from a national security perspective or from a law enforcement perspective? Is government justified only if government assets are risk or also private assets? Is part of a national security role protecting the economic well-being of the U.S.? If so, how far do you go? Disrupting the New York Stock Exchange? Okay, that's one thing. Protecting intellectual property being stolen from a U.S. company that simply weakens that company's competitive positioning in the marketplace? Is that a national security issue? How do you handle attribution? Right? A cyber attack doesn't come wrapped in a nice box that says "From Russia with love." Right? You're gonna come in through a server that you're going to take over at the University of Alabama. The origination of the majority of the cyber attacks that we see is from within the United States. But that doesn't tell you much about who's ultimately sitting back there with their fingers on the keyboard. Even if you can trace it back, say you trace it back to a student in a Chinese technical institute, is that Chinese student simply a malicious hacker? Or is he working for someone else? Is this an advanced persistent threat sponsored by the Chinese government? The attribution is very, very difficult. Lots of great questions in this area. It segues us into the whole cybersecurity debate that many of you know is very hot in Washington right now, a lot of discussion of potential legislation. That could be a topic for a whole nother topic, a whole nother panel. I'll simply make two observations in the cybersecurity view. One, the internet networks were designed to be open, to be accessible, to be flexible, and redundant, not secure. I would suggest to you that the analogous model for thinking about how we look at cybersecurity is how you deal with crime in a major metropolitan area, not how you secure the perimeter of a country from a military perspective. I think most cybersecurity experts will tell you the idea of securing the perimeter of the internet is a fool's errand. If for no other reason, it's hard to define the perimeter of the internet. Second point is, it is undoubtedly true, and I can tell you that I live this day in, day out at Verizon, that the thicket of laws that were written, whether it's FISA, whether it's Electronic Communications Privacy Act, whether it's the dozen wiretap laws across the United States that require two-party consent, were written at a time where I guarantee you no one was thinking about BGP, metadata, net flow data. These terms probably don't mean anything to you, but for those who are looking at the type of data, and see General Hayden nods his head, this is where the world, folks that are really thinking deeply of this are living today and thinking about what sort of data is useful for fighting these battles. And the laws that were written in 1978 or 1986 have absolutely nothing to say on that. We see it every day where we look at capabilities that we might have in fighting cyber that we can't roll out because the law simply is unclear. There certainly, at the very least, is room for clarifying the rules on information sharing within private industry and between private industry and the government and vice versa. Then finally, in closing, just want to make 3 quick points on sitting in-house from a national security perspective, because I think it's a slightly different perspective than many of you may live day to day. First 2 points are actually embedded in the term national security. When you're a multinational company, you actually have assets, you have employees in countries all over the world. In France, I'm a French company. In Japan, I'm a Japanese company. I have to comply with the laws in those countries. You often find yourself in conversations where someone says, you would like you to do the following, that is perfectly valid under the laws of the country in which you're having the discussion. That's fine, but you can't stop the analysis there when you're in-house counsel at a multinational company. You have to say, but what about the other countries in the world? Is it also in compliance with any activities taking place there? You have that obligation to your employees and your other stakeholders, your customers in that country. The second part is the security part. There are people, many of yourselves in the government, whose job it is to think about the national security, and I am glad that you're there. That is an important, it is a vital job, but it's not the same as the job I have as in-house counsel. I'm not the legislative branch, I'm not the executive branch, I'm not the judiciary. I don't get to be a policymaker. We can and should have debates about what the laws are and what they should be in order to arm ourselves best in this world. But as in-house counsel, my job is to counsel my client on what the laws are and how they need to comply with them. I can't live in a world where I wish the laws were something different, or I look at the laws as an inconvenience and simply tell my client, you can ignore them. My job is not to make the new policy, not to cut the edge, but to counsel my clients on what is legal and what they need to do to maintain compliance with the law. And then the third and final point is, when you work in this space in-house, it is very likely that many of your clients have come from the government. They are some of our most valuable assets because they know the way the world works. But you also have to be very conscious that that is also one of your greatest potential compliance vulnerabilities, because if I've worked with Phil for 10 years in the Secret Service, and suddenly I'm on the Verizon side, I know the types of things that would be very valuable to Phil. It's very tempting for me to say, hey, just look at my terminal. There's all this information flowing through it to be useful to you. But most of the laws that we have set up have to do with the boundary between the private sector and government and the rules around sharing that information. So you have to be very, very conscious of that world as we get deeply embedded with each other, that we not cross those lines, blur those boundaries, and find ourselves in out of compliance, which is good for neither private sector nor the government. Thank you.
All right, thanks very much for that presentation. Phil, yeah.
Hand the mouse over
Yeah.
and all.
Just to warn you, I'm going to play a little bit more Taskmaster here with you because we want to leave a lot of time for Q&A at the end.
So, you know, it's good as a former Army officer to see that PowerPoint's not a disease limited to just the military. And I promise you this will go quickly. I've got about 45 slides for 15 minutes, so we'll move through at a good clip. No, just kidding. Just 3, and they're all pictures, so they should be pretty easy. Calvin Coolidge famously remarked that the business of America was business. And I think there are a lot of problems with that quote, but I think it's interesting to think of the business of national security as business as well. And if you do, you know, it's useful to start with a couple of numbers. So in fiscal year 2010, the government spent $538 billion on contracts and $613 billion on grants. In fiscal year 11, it was $550 on grants and $536 on contracts. So about $1 trillion of the federal budget, which I think it's what, about $3 trillion overall, or give or take a few billion. That's a lot of money. It's almost as much as the Chinese are going to spend here, but it's a lot of money in a $14 trillion economy, and it has an effect on our economy and our society that is really quite singular. It's its own microeconomy. We learn in law school about contracts and business forms like corporations, but in the government contracts world, there's a whole new landscape, and there's a federal acquisition regulation that is the Bible of terms for government contracts, and each agency has its own supplement to that. And this landscape is very important for our economy. It's also very important for our national security, because the majority of U.S. capacity in this area is, in fact, private capacity. This has been historically the case. It's not new. It's not limited to KBR. And it reflects a policy choice. The U.S. is not the Soviet Union. We don't have a state-owned factory making Kalashnikov rifles. We have Colt. We have private companies making weapon systems, and that's historically been one of the largest uses of contractors. We have private companies making satellites and ships and aircraft and tanks and everything imaginable for the U.S. military and for a lot of other agencies as well. Especially in the intelligence community, where there are very large budgets for the acquisition of satellites. The VA, the second largest cabinet agency in the U.S. government, also spends an awful lot of money on acquiring goods and services. The traditional roles were things like major systems procurement, research and development. And research and development didn't just go to the contractor base, the defense industrial base. It went to universities like Duke or like my alma mater, UCLA, which rakes in about $2.5 billion a year in grants and contract funding. You look at the national laboratories, Sandia, Lawrence Livermore, et cetera. These are essentially contractors. They may take the shape of a nonprofit. They may be what's called a federally funded research and development company, but they're contractors. They're working for the government, but they don't actually work for the government. They just take the king's shilling and do what the king wants, but they are bound only to the government by a contractual document. Major reconstruction programs overseas have always been done by contractors. The Kajaki Dam, pictured above in Afghanistan, is a project the USAID built in the 50s and the 60s, and then we have tried to consecutively rebuild it for the last 10 years. The Kajaki Dam was built originally by contractors in USAID. Most of Egypt's telecoms infrastructure was built by USAID implementing partners. I think AT&T, was the one that did that, although they ended up in a lot of litigation, so it's not good for AT&T. And this has historically been something that contractors have done overseas, so it's not a new thing in Iraq and Afghanistan. And then, of course, the purchase of commercial items has been a massive area of government spending, everything from pens to computers to services from commercial providers like FedEx. This is something the government does. But that said, there has been a change, and you see it in photos like this. 70 years ago, when we fought World War II, we did so with a force of 16 million men and women under arms. Today, we're fighting our current conflict with an active duty and reserve force of 2.5 million. A deployed force in Iraq at one point of about 160,000 or so. And in Iraq at the same time, they had a deployed force of about 160,000 contractor personnel. The ratio is 1 to 1. That's higher than any conflict in recent history. There are lots of different ways to look at this change. A Civ Mill scholar like Mac Owens or Charlie Dunlap might look at this and say, well, who serves and what are the implications of that for our democracy? A labor economist might look at this and say, it's okay, but I worry about the most efficient allocation of resources. Who's cheaper, who does what we need and allows the taxpayers' money to go the furthest. A policymaker or a commander probably just worries about who gets the job done better. I don't care if it's the Red Ball Express trucking supplies across Western France or it's KBR moving things up from Kuwait to Baghdad. I care about who gets the job done. And then the lawyer probably wonders about, and I'm sorry for 4 questions, it's just after Passover, so I've got that on my mind. Is outsourcing legal? What disputes arise? What are the points of friction in this system? I think all of these are incredibly important questions. But first, let's talk about why this change has taken place. I locate it in the 90s, really. The change happened towards the end of the Cold War, after the first Gulf War, when you had a few things come together that really were sort of one of those inflection points in national security, similar to when the all-volunteer force emerged, similar to the creation of the National Security Act. But a lot of these happened under the radar. There was no deliberate policy shift that said, aha, we're now going to use contractors to do our logistics in the military. The first of these was the reinventing government movement. This idea that you could outsource whole swaths of government to the private sector and force the government to compete with the private sector for certain services. And you see this through what's known as the A76 process, where agencies can look at a discrete part of their operation and compete it with the private sector to determine who's going to be the most efficient and effective performer of that. The idea is the most efficient performer should do it, setting aside those things that are what are called inherently governmental. And there's a list of those in the FAR, but it's not really a definition that makes necessarily a lot of sense in the real world. The second change was the post-Cold War force drawdown. So you went from an active duty army of 780,000 or so to about 480,000 in a span of a few years. The missions didn't go away. In fact, the missions went up. During the 90s, as many of you know, the U.S. military deployed more than it had in the previous 40 years to such places as Bosnia and Haiti and Kosovo and the Philippines and elsewhere. And that's only continued to go up. But what this did was really constrain the amount of force structure available, and also the military made cuts in certain ways because it felt that it could assume risk in certain ways. So they proceeded on the theory that we can cut combat, we need to preserve combat forces, but we can cut logistical forces. We can outsource those things to the private sector or to our reserve components while preserving the combat power of those forces that we actually need to do the most critical tasks on the battlefield. Similarly, you had the emergence of a lot of troop caps in the 90s on these deployments. In the Balkans, the initial troop cap was around 25,000, and then it settled in at 10,000, it settled in at 5,000. That necessitated a kind of shell game. So if you could have 5,000 troops on the battlefield, well, I'm going to get as many of those troops to be combat troops, but then I'm going to hire Brown and Root to come in and do the rest. Or I'm going to hire some other company to come in and do my construction work because I want those 5,000 people to be infantrymen and military police and special forces to actually get the job done. And then you also had very deliberate decisions to assume risk on entire types of capabilities. The military had no meaningful translation capability in the 90s. The military had no meaningful security force assistance capability aside from that was resident in the special forces. And these choices came home to roost on 9/11 when we were faced with a cliche, a new kind of war, but really a new set of requirements, a new set of demands that stressed our force structure in very difficult ways and forced us to go to where we are today, which is a much different picture of acquisition than we had even 10 years ago. So in addition to all of the traditional forms of procurement, weapon systems, commercial purchases, R&D, et cetera, you now see a much higher level of contracting in the civilian space. You see, particularly in healthcare and in what we call sort of staff augmentation, or pejoratively butts and seats contracting, you see an enormous amount of government capacity actually being performed by the private sector. In addition, though, you see a lot of other stuff, and this is where the problematic area begins. The provision of security on the battlefield by companies like Blackwater and Triple Canopy. The provision of battlefield logistics by companies like KBR and DynCorp and Fluor. The provision of not just foreign development, like USAID has always done, but battlefield reconstruction in places like Iraq and Afghanistan while the conflicts are still underway by Parsons and Bechtel and lots of other companies. Translation support. Currently, a company called Mission Essential Personnel provides 8,000 translators to the U.S. military for work in Afghanistan. Most of those are local nationals, but some number of those are also U.S. citizens. A massive amount of the military healthcare infrastructure is provided by contractors through TRICARE and as TRICARE contractors. And the list goes on. And this creates, it's fraught with peril. I mean, it's a minefield of legal disputes. It's a minefield of performance problems. I just want to run through a few of them because I think that they correlate to some of the CivMil questions that folks like Mac and Charlie study, but also some of the real difficult questions for practitioners. Who do contractors work for, and who gets to sanction them when they do badly? This is essentially a jurisdictional question. In the past few years, you've seen a few cases like United States versus Ali, where the U.S. military, for the first time in decades, prosecuted a contractor under the UCMJ, and we're now seeing that case percolate up through the military justice system. It was just heard by the Court of Appeals for the Armed Forces. We should see a decision soon. Raymond Davis, the CIA contractor in Pakistan, who was arrested by local authorities for allegedly shooting 3 Pakistani citizens. His status, his conduct, who gets jurisdiction over him, these are all live questions, and there's no settled answer for contractors in all of these cases. How does the government align this with policy? One of the most significant uses of contractors in the last 15 years was the use of contractors to train the Croatian military in 1995 to equip them with what they needed to succeed. We used MPRI to go out and train that military and use a lot of retired generals to essentially transform their force. They couldn't do that without a license from the State Department that allowed them to export defense services and technical data. That's one way that we align policy, but we don't have a lot of other mechanisms like that. We don't have a good mechanism for the injection of the law of armed conflict into contracts. There's a requirement that, and it's in a FAR clause and a DFARS clause, that contractors have a law of war program, that contractors certify compliance with the law of war. But how does that get enforced? The government has no privity of contract with their employees. They can't issue a direct order to them in the same way they can with soldiers. They can, in some cases, direct compliance to the contractual chain of command, or in more extreme cases, terminate a contract or withhold costs, or in the most draconian example, bring a False Claims Act suit against the contractor saying that they didn't actually provide what they were supposed to because they didn't comply with this clause. But it's a very imperfect mechanism. And then how do we hold companies accountable for performance? This is still very much a work in progress. You see it emerge in the tort context with things like the KBR burn pit litigation. You see it in the context of performance on projects and the way that the SIGR, the Special Inspector General for Iraq Reconstruction, and others go out and evaluate performance. And then last, I want to close on something that will segue into what Will may be talking about today. Who cares for contractor personnel when they serve alongside U.S. forces? We field the whole of government, but we only provide veteran status to those members of the armed forces that serve in the military. We have a shadow population of 400,000 or 500,000 American citizens who have served as contractors in Iraq and Afghanistan. They will have no access to the VA. They have a Defense Base Act insurance scheme, which is similar to workers' compensation, but not as effective. And it's unclear who's going to take care of them in the years to come. So I want to close there because I'm out of time and look forward to the discussion.
Great. With that, I'm just going to go ahead and open up for questions from the audience.
Thank you.
Please, right
Hello,
here.
Chris Fallon, student at Florida State University Law School. You hear it said occasionally that U.S. corporate offensive cyber posture might violate the Neutrality Act, but no one has been very specific about that. For instance, China attacks Verizon. Verizon responds in some way. As I understand, it's possible for that response to violate the Neutrality Act. Pentagon officials have indicated that a cyber attack against this country might be construed as an act of war if it damages our critical infrastructure. I guess my question is, do you think we could use that same effects-based approach and apply it to a Neutrality Act inquiry such that Verizon would only violate the Neutrality Act if it damaged China's critical infrastructure?
Anyone want to take that?
You know, yeah. So, yeah, this is an interesting question, Chris. And I guess I would back up actually from the premise, right? So the premise is that Verizon, in your example, is being used as a vector of attack, but we're now getting into the question of knowledge and active participation, right? So I would say from and I'm going to walk carefully here because this gets into some sensitive areas, but from a company perspective, I think there is a lot going on through my networks. I do not know what every bit is going through my networks. And that applies, frankly, generally. I can't tell you if a bit of traffic is a copyrighted, a copyright violating MP3 file. I can't tell you whether it's child pornography. There's certain things you look in on servers. But if there is an inbound attack, the offensive role, I would say that it is very important for a company like Verizon to have a passive role when it comes to armed conflict between nation states. There is absolutely no benefit to a private company becoming an active participant in offensive cyber operations between nation states. Now, so what I would analyze it actually is under the traditional, say, Computer Fraud and Abuse Act type analysis, which would apply in a civil context that says, if my assets and my network and my customers are at risk, I now have a right to take certain actions. I have the right to take actions to protect my network, to protect my customers, to intercept traffic, to block traffic and whatnot. But I would approach that situation. In fact, we do approach that situation because we are dealing with inbound attacks all the time. And we deal with them from a civil legal perspective in terms of our rights to protect our network under Computer Fraud and Abuse Act. I have no way to know, and I have no desire, frankly, to eat of that tree of knowledge of what I'm dealing with is a state-sponsored attack that draws me into somehow a witting participation in a state-to-state conflict.
Over here.
Just following up on that, sir. My name is Todd Lindquist. I teach at the U.S. Army JAG School in Charlottesville, International Operational Law. Definitely understand your intent to remain passive, but the Deepwater Horizon incident demonstrated a difference in capacities between the government and the private sector in being able to respond to that natural disaster, and the reliance by the government on the private sector to respond to that disaster. And so if for some reason the government, maybe from your view in cheap seats, not necessarily there at Verizon, but maybe in your community, are you seeing a difference in capacity to be able to respond to such cyber attacks between the government and the private sector? And would the government necessarily have to rely on the private sector and bring them into some type of cyber incident?
Yeah, so that's a great question. What I want to distinguish here is, and I think implicit in the two questions, is an offensive versus a defensive capability. Okay, so part of what I'm saying is I can't speak for all industry participants. I don't want to speak for all future capabilities. The question, and let me just put this as a hypothetical. Hypothetically, U.S. government comes to Verizon and says, will you develop for us offensive cyber capabilities that could be used on behalf of the U.S. government in which Verizon would have some active role? I would simply suggest to you that there are serious questions that would have to be thought about very carefully at very senior levels of the company of the degree to which you want to go into the business of developing offensive cyber capabilities. I won't say any more than that, other than it would obviously have very, very careful consideration for the implications of that. Defensive, I think, is a very, very different world, because defensive is a world that we live in every day protecting our networks. And I would say that the answer is neither. It's not an either-or proposition. The government has great capabilities in the cyber world in its ability to protect its own networks, and that's resident in certain parts of the government more than in others. But I do believe that the private sector also has tremendous capabilities, and there is a role to play in the same way that we provide security for Bank of America, for NASDAQ, frankly, around the world, London Stock Exchange and others. We certainly have capabilities that can be brought to bear in a defensive capability for U.S. government networks. And then you do get into a more nuanced, frankly, both the private sector and on the government side. Are you talking about military networks? Are you talking about civil, sort of the .gov networks versus .mil type networks? There are going to be nuances to the question, but offensive raises a host of issues that any company would have to think about very, very carefully. Defensive, absolutely. I think that's a shared area of expertise where government and private sector work very, very well together.
Let me pile onto that a bit. I mean, essentially, that arrangement would make Verizon a contractor. And
absolutely.
If the government asks you to develop essentially a weapon system like that, you would be very akin to a Lockheed or a Boeing. And there is, in fact, a lot of that work going on both at a sort of steady state level with the development of the Cyber Command and other agencies. There are contractor personnel that are enmeshed in those efforts. There are also entire systems being developed by the contractor community. The government protects them to some extent by having things like the government contractor immunity doctrine, or what's sometimes called public law 95-804 immunity. There are a variety of doctrines that contractors use as a shield to liability in these cases, starting with the political question doctrine. In some cases, they will shield themselves with invocation, a request for invocation of the state secrets doctrine, and others. But contractors are very much in the fight. And I think it is with the knowledge that they are directly participating in hostilities by doing so. And that is a willing choice. The wisdom of that may not have been debated very much. It certainly hasn't been debated by policymakers or judges or others, but some of my competimates in the contractor community that do this kind of work know this is what is going on. They're in the fight, they're willingly in the fight, they're making a profit by being in the fight, and they accept the risk that comes with that.
The one, and I think that's a very important point, Phil. The one distinction I would make, and by the way, on the defensive side, I think it's a matter of public record that we are a contractor, and we provide cyber capabilities on the defensive side generally as sort of a far general public contractor. On the offensive side, I think the difference with a Lockheed is what's interesting in the cyber world is where the network itself is the vector of an attack and it's self-contained. You have to push the analogy a little bit further. It's not Lockheed just producing the airplane. It's Lockheed actually flying the airplane in combat. And I would actually take it beyond Lockheed. It's when your entire asset base is in fact part of the asset that you're talking about deploying and actively participating in as an attack. That's why I say I think there are, I'm not saying you couldn't do it. You could become a government contractor, do it. There are serious questions you would have to ask yourself as a company that you say, I have a $100 billion asset that is my entire company. I am now going to become a contractor using that asset in itself as me being the active catalyst for the attack. I would suggest that's a pretty heady decision to make as a company to insert yourself that proactively into the arena.
Over here.
My name is Rochelle Howard. I'm an 8-year veteran, previous veteran of the U.S. Army JAG Corps, currently an MBA student at University of Maryland University College. So back to and we're actually studying international business this semester. So back to the international business side of things, as a multinational enterprise, when you choose either to be a government contractor or to start business in a foreign country, when you have to consider things like human resources and the supply chain and how you're going to build that company in a foreign nation, what business factors do you take in place, and then how do those specific factors counter with you being a U.S. company having to take into consideration the national security concerns?
Ted or Phil?
Very good and perceptive question. The supply chain security is, one of the biggest issues that's bedeviled the defense establishment over the last 10 or 15 years. Again, something very new focus. It has started, and a lot of the focus still continues to be in the semiconductor area. In 2005, I think it was, then Deputy Secretary Wolfowitz issued a directive that ultimately led to something called the Trusted Foundry Program, where ultimately the goal is to have all semiconductors that go into military systems be fabricated in the United States. One of the reasons behind this, not only is the obvious security reason, was that virtually all foundry capacity had left the United States over the previous 15, 20 years. It had all migrated mostly to Asia. And there have been numerous troubling incidents of components, whether it's in your BlackBerry or your iPod or devices, mobile phones or elsewhere, where the flash drives were found to be programmed to open back doors and turn them on and start sending information back. So the defense establishment is very focused on supply chain security, as it should be. But there are two issues among many, just to note. One is going very much to to the perceptive comments of Phil, the defense establishment in the U.S. relies completely on industry to produce most of what it needs. And technology advances cannot be done without global collaborations these days. And so it's just inevitable in the global supply chain world that we're going to have components coming from abroad. I think U.S., there are rules governing origin, but I think U.S. companies also, in their position as suppliers, have to be very careful about where they source things. The other thing is just to emphasize the role of foreign-owned companies in this world. To take the examples that Phil and was discussing earlier in the cybersecurity space, suppose that, in Scott's world, suppose the company being approached to engage in cybersecurity work is foreign-owned. And there are many out there, wonderful companies in the U.S., BAE Systems, one of the major British-owned companies, deeply involved. There's another dimension there. They're key parts of the defense procurement establishment. They're foreign-owned and will continue to be.
If I could just add one or two comments. First, on the pure national security perspective, there's one aspect of it when you're looking at other countries that actually tends to take care of itself. You would take a guess at how much in the way of sensitive communication services we provide to the Russian government. I'll tell you the exact same amount that the U.S. government buys from Russian companies is the answer, which is zero, right? But sort of by definition, in certain countries, they're not going to hire a U.S. company to do their sensitive communications or cybersecurity defense for the same reason the U.S. government's not going to hire a Chinese company to do it. So there is, to some degree, at a basic national security level, it defines itself. Where things get interesting, India is a great example right now. To Ted's point about supply chain, the Indians are very concerned about the Chinese. Most equipment is made in China. The Indians recently passed a law that said any equipment that goes in your network in India, within 3 years, you have to commit to handing over all of the intellectual property, all the technical specs, to an Indian company. Right? This is partly industrial policy to grow a homegrown Indian tech industry. Partly it's because they want to know what's inside those boxes. That's raised some real issues as we work with equipment suppliers of how do we operate in India. And then finally, a major issue that you always look at, there's lots of issues where you go into a country, do you see good opportunities, things like that, but you certainly always look at the security situation and you look at the, from Foreign Corrupt Practices Act. I can tell you there's a country, I won't name it here to not to disparage it, but we did business there for several years and we actually pulled out of the country altogether because I got to the point where I said, I don't believe we could actually win any business there without me assuming corruption was involved. The corruption had gotten so bad. FCPA is actually one of the major factors you consider in where you do business.
Yes, here in the middle.
My question is for you, Craig, actually, but also perhaps for the rest of the panel. It strikes me as you describe the thicket of law that governs telecommunications, but that is an emerging field of study, obviously. Right. Picking up on General Hayden's point, that the football field is kind of being described in a public-private partnership. And my question is somewhat of a corporate ethics question of what is the right role for the corporation in that process where intuitively the corporation's objective might be to draw that sideline in a more litigation-proof manner than the national security apparatus might be inclined to draw it.
Yeah, sure, it's a great question. It's one we wrestle with quite a bit. I would say that the following. Let me tell you how I think we have tried to handle it over the last couple of years, certainly. We think it's valuable to have a dialogue where as the technology evolves, it's important to sit down with the proper constituents that may be the potential consumers of the capabilities that you're talking about, and the Department of Justice. It becomes an important constituent in that discussion to say, here are capabilities that we have the potential of offering, but today the legal process for providing that type of information is unclear. We think it would be useful to have that discussion on Capitol Hill. Now, it's interesting the way you proposed it, that we might be more litigation sensitive, and I think that's true. If it's a situation where the government simply comes to us and says, we want the following, you need to operate in that gray area. That's a tough one. When you are looking at your fiduciary responsibility to your stakeholders, your employees, your customers, your shareholders, listen, it's a matter of public record that Verizon's been in litigation for 8 years over the FISA litigation now. It has been a major issue for the company, and I will say at no point ever has there been any public statement from anyone that we actually had anything to do with the program. That doesn't matter. We have been in litigation for years and years on that, and we've stared into the abyss. So does that factor into our thinking? Absolutely. But the flip side of that is I want to be careful about not looking opportunistic. I don't want to look like I'm going to Capitol Hill and saying, change the law because I can provide these services to government. So the way we have approached it is really to try and play it down the middle. Say, this is the way we try and work with our partners in government. Say, this is where we see the technology going. These are the capabilities we have. These are the challenges in the legal regime. Let's begin thinking about this together and talk about how we present this in a coherent way before you're having to deal with it in a crisis situation. It's worked better sometimes than others, but it's an ongoing dialogue, and it's taking place now.
All right, let's do one more question in the back.
Hi. This actually follows pretty closely on the previous question. I was wondering, at least two of you and maybe all three of you spoke of the privatization of government services, but you didn't really discuss the privatization of law. And I was wondering if you saw that happening, if you saw quasi-legal or sub-legal or semi-formal arrangements, either within industry or multi-stakeholder initiatives between industry, non-state actors, and maybe even states that are playing maybe a global regulatory role here. And if so, where do you see that heading?
Go ahead, I have some thoughts if you want.
Yeah, I mean, one quick example would be the use of arbitration as a mandatory clause in many government contractor personnel relationships, such that any issues about accountability for actions on the battlefield, whether it's a straightforward sexual harassment type issue or it's the use of force at a checkpoint, get handled through a private arbitration process with no opportunity for injection of public norms. I think that happens, it's very real, and it is the landscape upon which we play.
And I would say, sorry, just one quick, no examples spring to mind in the national security space, but this happens quite a bit throughout the industry. We have standard setting bodies. If you look in the privacy world, we have lots and lots of codes of industry agreements on self-compliance where the Federal Trade Commission enforces compliance with what you're promising publicly. There are a raft of examples, I would say, generally, of industry self-regulatory examples. None pop to mind in the national security arena per se.
That sounds like a great subject to pick up during the break. I think we have one more point.
Ted would like to pose a cliffhanger question to all of you to end the session.
It really picks up a point that several of you have mentioned, and Scott and Phil have emphasized, which is a lot of these things that we've talked about are settled through very close discussion and cooperation between industry and government. It's certainly true in the CFIUS world. It's just an essential part of the process. But we all have to advise our clients on these very close questions and what gets to the line. And I've been pondering ever since last night, General Hayden's just wonderful remarks, this analogy that we've now heard repeated several times. And I won't ask General Hayden to answer this question I have, but if you get chalk on your cleats on the football field, are you out of bounds or in bounds? As opposed to, say, baseball and soccer, yes, where the chalk is inbound. Well, I don't answer that.
Produced by Duke University. Online at duke.edu.